Judge Young presiding.
All right. Good morning. I understand we've been having some Wi-Fi issues, and hopefully we got all the electrons working properly. Got a lot of people depending on them. So. All right, we got a pretrial motion for the defense has filed to dismiss the case. That looks like it should go first. You ready?
Defense calls Barbara Moore.
Please raise your right hand. Raise your right hand. Do you swear or affirm the testimony you should give the court in the matter of this case shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
You may be seated right here. Please state your full name for the record and spell your last name.
My name is Barbara Harris Moore. It's M-O-O-R-E.
Miss Moore, my name's Bill McGuire. I represent Michael.
Yes,
I'm one of the lawyers representing Michael. And I'm sorry to meet you in these circumstances.
Thank you, Mr.
And
McGuire.
I'm sorry for your loss.
Thank you.
And I also want you to know that even though you're the first witness, this hearing doesn't have anything to do with you. You did nothing wrong. There's no reason to be nervous at all, okay?
Thank you.
Okay. So the judge just needs some information so he can rule on an issue. So the information that I want to ask you about today is really for him. So if you want to look over at him when you answer, so he gets it, that's fine. Okay.
I'm sorry.
You're fine. You're fine. So I need to ask you a little bit about a day, about 2 weeks before Sarah's passing. And that's the day, if you remember, when you went to Sarah's house and she was crying and upset. Do you remember that day?
Yes, I do.
Okay. And when you went over there, Sarah was crying, right?
She was.
And she looked very upset.
She was.
And she had cried so hard and so long that her face was swollen. The puffy eyes. And that concerns you.
Yes.
And you actually wanted to take her to the hospital to get professional help
I did.
because you were concerned about her emotional state.
Yes, sir.
And one of the reasons you were so concerned about her emotional state is that she made this statement, if it wasn't for the girls, I would hang myself in this garage.
Yes.
Okay. And that caused you great concern.
Yes.
And that's why it stands out in your memory.
Right.
And after Michael was arrested, there was an agent from SLED assigned to the case. His name is David Owen. Do you see him here today?
I do.
Is he the fella on the first row there with the red tie?
Yes, sir.
Okay. And he issued a report, and I think the first visit you had with him was at your house August 5th. Does that sound right?
I'm not sure the date, but it sounds right.
Yeah, it's been a decade. It's been 10 years.
Yes, sir.
The first visit, it looks like, based on his report, that it was about a 2.5-hour visit with you in your house. Does that sound familiar?
I just don't remember. It probably was. I just don't remember.
Sure, I understand. But you did tell David Owen about that day when Sara was crying at her house. Her face was swollen. She said she wanted to hang herself. And I believe you told the prosecutors that when you told him that, it was in your kitchen at your house. Does that sound right?
It was in the breakfast room of our
Okay,
house.
so your kitchen, it sounds like it might be like mine. You have a kitchen, the kitchen part, then you have like a little breakfast table?
Yes, sir.
Okay. And I'm assuming that David Owen wanted to use the table so he could put his file on it and put his notebook on it and take notes.
Yes, sir, I guess.
Well, obviously when he's interviewing a very important witness in a very important case, the most serious charge in South Carolina, he's going to have his notebook and he's going to take notes, and he needs a flat surface like a desk or table to do that.
Yes.
And he did that in your kitchen.
Yes.
Okay. Was there anybody else with him that day you told him about the Sara cried?
My husband was there.
Okay, Ronnie? And I'm sorry, but I think he's passed since. Okay.
Yes.
Was there anybody else?
No.
Okay.
No. I'm not speaking up. I feel like I'm not speaking loud enough.
Ms. Moore, you're fine.
Okay.
You're fine, okay.
He said I was fine, so
I can hear you fine.
okay.
And I think the microphone can hear you fine too. And as long as Madam Court Reporter can hear you, she's the most important person. So if you want to talk to her, that's fine too. So you're in the breakfast nook where Mr. Owen has his notebook and he's taking notes, and you tell him about the statement. Can you, and I know it's been a long time, but can you tell me basically what you told him?
I can't remember verbatim
Do the best you can.
what I did, but I left school that day. I was still teaching, but I was only working a half a day. I went from school straight to Sara Lynn's house. I just wanted to see her. And she was there by herself. And the front door was open. So I went in, and I went into they had turned their garage into a den. So she was in the den, and she was crying. She was crying a lot. And I put my arms around her, and I pulled her to my stomach, and I said, "Honey, what's the matter?" And she said to me, "Mama, you wouldn't understand." And I said, "Honey," and she pulled away, and she said, "If it had not been for my children coming home today, I would have hung myself in this garage." And I pushed her back, and I said, "Sara," and she said, "Mom, I wouldn't do that. I wouldn't do that to you, but I sure wouldn't do it to Bishop." And that's exactly what I remember her saying. Then Michael came in. And
Okay. And you told Michael that y'all should take her to the hospital.
before I left, I asked Michael to come to the foyer with me. And I told Michael exactly what had taken place and that I wanted to take her to the hospital.
And I think you even offered to pay for it.
I would have paid it.
Because you didn't want the cost of care getting in the way of getting the help that Sara needed.
Exactly.
Okay. When you told David Owen that, he must have had questions for you, follow-up questions. Do you remember what he said?
No, I don't.
Okay, but you just
I
saw him
don't.
write it. You saw him write it down.
I can't even remember that, Your Honor. It's been 10 years. I remember us sitting around the table, but I don't remember whether, I'm sure, I just don't remember.
That's fine. That's fine.
I can't remember paper and pencil.
Okay. What about a tape recorder? Did he make any effort to record the statement?
Oh, gosh. I do not remember.
Okay.
I can't honestly tell you yes or no.
Okay. Well, what about, I mean, that's, he must have been impressed by that information, and he must have taken it seriously. And can you remember any follow-up from him? Like, how long has Sara been like that? Has she ever gotten help before? Any kind of follow-up questions?
I don't recall any at all.
Okay. Okay. Well, it's been a
I
long
don't
time.
recall being questioned about anything.
Okay.
Yeah.
So on his first visit, on August 5th, that visit was about 2.5 hours. So he must have asked you some questions.
We talked for a long time,
Okay.
but I don't recall being questioned.
Well, you had a
You know,
conversation.
it was like, yes.
I don't mean to imply that it's a police interrogation or
Okay.
anything like that. He had a conversation with you.
Yes.
Yeah. And in that conversation, did he follow up about that issue with Sara saying she wanted to hang herself? Did he follow up at all that you can remember in this conversation?
Follow up.
Yeah, well, you know, somebody tells an investigator that Sara made the statement that if it wasn't for the girls coming home that afternoon, she would have hung herself. And then 2 weeks later, she passes under circumstances that indicate she was hung in a hose. When he learned that, can you remember how he treated that information or what he did with it? Or did he ask you about, had she made statements like that before? Well, I'll ask the question. Sara made statements like that before, right?
Oh, never to me. No,
Never to you?
never.
So if somebody was to say to you, and I'm not saying this, but if somebody was to challenge you and say, well, how do you know you told David Owen that in your kitchen? Is there anything that brings that memory back to you? Well, I interview a lot of people at kitchen tables, and sometimes details come back to people and things are connected to the timing. For instance, you and Ronnie may have had plans to go to a restaurant or go see family. Do you remember anything that was connected around that time?
Anything that was connected.
Around that day? Any, like, where you had come from, where you were going?
No, sir.
I understand. He got there around 10 o'clock in the morning and concluded the interview around 12:30, and I know you probably don't remember those times.
No, I don't.
But it is a long time. Did you offer him anything to eat or drink? Sometimes people remember having a conversation with somebody and they say, you know what, we had lemonade, and he said he really liked it. Can you remember anything like that?
My husband gave him a glass of grape Kool-Aid.
Grape Kool-Aid.
Grape Kool-Aid.
Did David Owen enjoy the grape Kool-Aid?
If he didn't, he didn't say he didn't. Because Ronnie did.
Okay. Well, who drank the grape Kool-Aid normally? Was it Ronnie?
Just Ronnie.
Just Ronnie? And he shared some of his grape Kool-Aid with David Owen?
Yes, sir.
Okay. So the next time, there must have been another discussion where this statement came up, and I'm guessing it's when you met with the prosecutors to get ready for the first trial. And that would have been in 2018. You would have met with the prosecutors and discussed that statement. Do you remember that?
No, I don't.
Okay. When's the first time you told the prosecutors about this?
I don't recall telling the prosecutors about it. What I remember when I met with them, it was like they were telling me, asking me, I guess. I wasn't telling them stuff. It was, I guess everything was already told. I don't know. But I
Right.
do not recall
Okay.
going over that
And they would.
at all.
Okay.
I mean, none of the things that I had said, I just don't recall going over 'em. It's been a long time.
I know. Yeah, I'm sorry to put you in this position where I'm
That's
asking you
okay.
to try to remember things.
I know.
It's so long ago, and I don't mean to put you in that difficult position. So I'm gonna get you, if you would, to watch with me a little portion of your testimony from the first trial,
Okay.
where this subject matter of Sara being at home and crying and being very upset, where you talk about that with the prosecutor. I'm gonna get you to watch it, then I'll ask you some questions about it. Okay?
Where am I going to watch it at?
Judge,
Okay.
you can play that.
What was her demeanor?
Oh, it's
She had cried until her face was just swollen. I said, "Oh my gosh, but honey, what's the matter?" She was sitting in the chair.
Let's not say anything that she said.
Okay.
It's all right. Take a minute. Just describe how she was acting. Did she appear upset or happy?
She was very upset. She was crying. Her face was all swollen.
Did you get an understanding in that interaction with her of what was upsetting her?
I did not. What I said, "Honey, what in the world is the matter?" And she just said, "Mommy."
Don't say anything that she said.
Okay.
Um,
Sorry.
so following this interaction with her, did you, how did you feel?
I was very concerned.
listen, John. So when the prosecutor is saying, "Don't say what she said, don't say what she said," it seems to me like the only thing that Sara said to you was, "If it wasn't for the girls coming home, I would have hung myself in this garage." Is that what the prosecutor is referencing when she says, "Don't say what she said"? She didn't want you to say that, right?
I don't know. I think I wasn't supposed to say. I don't know. That's all I can tell you. I don't know.
Okay.
I don't know what somebody was thinking. I mean, I know what I answered. And I don't think that I was supposed to, through anything that I said, any questioning, I couldn't say what she said. It
Yeah,
was,
there's some
it had to
rules
be
in-
things that I witnessed. I guess, I don't know. I'm sorry, I don't know.
That's okay, but you remember having a conversation with the prosecutor, and they said there are some times where you can't say what people said.
I don't think it was them. I think it was somebody else. It was somebody else.
Okay. All right.
It didn't have anything to do with this trial. That-
I'm sorry?
I said it was someone that didn't have anything to do with the trial.
Oh, who was that?
Just a friend. I mean, I don't even know. If you want to know God's honest truth, I couldn't tell you his name if my life depended on it.
Okay, okay. When you met with the prosecutor to prepare for that first trial, do you remember Megan Burkstead?
Making what?
Burkstead?
Making Burkstead.
Yeah, Megan, the female prosecutor.
Oh, Megan. Excuse me. I thought you said making
Oh, sorry.
Burkstead, and I didn't
So-
know what Burkstead.
Yeah, Megan
Yes,
Burkstead.
I remember Miss Megan.
And when you met with Megan, there was always somebody else there. You never met with her alone, is that right?
That's right.
Okay. And
Oh, my
so-
husband was there.
Okay.
You know, Ronnie was always
How
there.
about somebody other than Ronnie?
No,
You know, just Megan?
I can't recall. Oh God, I can see the table. I think Joel was there.
Okay.
I think Joel was there.
Yeah, Joel's the fellow behind me here in the blue jacket and the red tie?
Yes,
Okay.
I think. I don't know.
Okay. Judge, if I could have just 1 second, ma'am. So, Ms. Moore, when you would meet with Megan and Joel, that was to prepare for court, right?
Yes.
And they were telling you how your testimony would go, the questions they would ask, that sort of thing.
Yes.
Okay. And how many meetings like that were there?
One at the sheriff's office.
Would that be the sheriff's office on live vote?
Yes, I think it was 2.
Okay, two in-person meetings.
Yes.
And as far as you can remember, Ronnie would be there, and you think Joel was there too?
I think so. God only knows, I can't remember for sure, but I know my husband was there and I know Megan was there. I think Joel was there.
Okay, that's fine. That's fine. When, after Ronnie gave David Owen the grape Kool-Aid and he concluded your visit, did you and Ronnie talk about that statement that Sara made to you, that she would hang herself?
Did we talk about that statement that day?
Well, did Ronnie say anything like, I'm not sure we should have told him that could hurt our case against?
Oh, no.
Nothing like that?
No.
Did Ronnie hear that statement for the first time when you told David Owen? So it was new to him, or had y'all talked about it before?
I'm sure that we had talked about, that I had told him.
Okay.
He was my husband, of course, and that was his daughter.
Right, and you would have told him that you were concerned and you wanted to take her to the mental hospital.
Yes.
To get help, because it
Yes.
was very upsetting and it concerned you greatly.
Yes.
When you told David Owen about the statement, did he say that? Did he say anything like that must have been very hard for you? How did you deal with that?
I don't recall.
That's fine.
I don't remember.
That's fine. And again, I don't want to put you in a position where it's hard to remember things. I think that's all I have for you, man. I'm sorry to
That's okay.
meet you in these circumstances.
No. You're very kind.
Thank you, man.
Ross?
Yes, Your Honor. Hi, Ms. Moore.
Hi.
I want to talk to you a little bit about the circumstances surrounding you speaking with David Owen, initially in your kitchen.
Okay.
All right, and so David Owen came and spoke to you on August the 5th, right?
I'm not sure the date, but it was around that time.
And at the end of that time that he met with you, he asked you to write a statement. Do you remember that?
I do.
Okay, and you wrote that statement and then subsequently gave it to him a couple weeks later. Do you remember that?
I do.
Okay, and in preparation for this trial, you had an opportunity to review that statement, right?
Right.
Okay, we met a week or so ago, and I asked you to read that statement in
Yes.
order to refresh your memory. Do you remember that?
I do.
Okay, and within that statement, you didn't write anything about the garage, right?
Right.
Okay, so that wasn't in that initial statement that you had written for David Owen. Is that fair?
That's fair.
Okay. Now let's talk a little bit about the statement itself, okay? When you first got over there, it was just you and Sara Lynn. Is that fair?
Yes,
Okay. And then ultimately, Mr. Colucci, Michael came home, right?
yes,
Okay. And you actually went and talked to Mr. Colucci, didn't you?
I did.
Okay. And you told him what Sara had said, right?
I did.
Okay. Now, when you say you had told him what Sara had said, did you tell him that she said she was going to hang herself?
I did.
Okay. And at that point, you offered to take her to the hospital, right?
I did.
You even offered to pay for it, didn't you?
I did.
Okay. But Mr. Colucci said no, right?
Right,
And so you ended up not taking Sara Lynn to the hospital that night.
right.
Now, when you were talking with Sara Lynn that day in the garage and she was upset, did she tell you why she was upset?
No,
Now, I want to talk a little bit about your meetings with the Attorney General's office and kind of your preparation for trial, okay? You'd agree that I wasn't on the first trial, right?
right,
Okay, so you met me sometime later, is that right?
right.
Okay. And the first prosecutor was Megan Burkstead. You remember her?
I do.
Okay, and then you remember Mr. Kozak, right?
I do.
And then there's other people of our office, other staff that you're familiar with as well, right? So Investigator Matt Ellis, right here in the glasses.
Yes,
Okay, and Mr. Investigator Ellis joins us on our meetings, right? The majority of
Right.
the time. Okay, and then you're familiar with our victim advocate, Tricia Allen.
yes,
Okay, and Miss Allen joins us on our meetings, right?
yes.
Okay, and then previously there was a victim advocate, Vanessa Payton. Do you remember Vanessa?
I do remember Vanessa, and I'd forgotten that.
Yeah, so there's other members of our office that you're familiar with as well from these meetings, right?
Right.
And every time we meet, Miss Barbara, it's not to go through your testimony or anything like that, right?
Right,
Is it fair to say that sometimes we meet just to update you on the case, right?
right,
Let you know the lay of the land, what's happening, how it's progressing, right?
right.
And then, do you remember once I kind of came on board, I believe it was in 2023, we met and we did talk about the case, right?
Right,
Okay, because I hadn't been able to speak to you before about it, right?
right.
Okay, and this is when we had that conversation about Sara Lynn in the garage. Do you remember that?
I do.
You remember us having that conversation?
I do.
Okay, and you don't remember, or do you remember ever having that conversation with Megan Burkstead?
I don't. Can I explain why I don't?
Sure.
Because that wasn't the question. That wasn't what we were talking about. We were talking about something specific.
And then in preparation for trial, it sounds like maybe you talked to a friend who told you about kind of hearsay, how you can't say what other people said on stand. Is that fair?
Yeah, because she watches Perry Mason.
Okay, so you have a friend who watches Perry Mason and she had told you that you can't say what other people say. Is that fair?
Yeah,
Okay, and throughout your entire direct examination, I believe Ms. Burkstead kind of stopped you from saying what some other people said. Is that fair?
yes,
Okay, and I think even the clip we just watched, you looked a little maybe flustered or frustrated because you were trying to say what someone else had said but knew that you couldn't. Is that fair?
yes.
You're out of time, just one moment. Your Honor, I have no further questions for Ms. Moore on this matter.
Redirect.
Nothing further.
Go ahead. You may step down. You have another witness?
I'm going to call Matt Ellis.
Do you solemnly swear or affirm the testimony you shall give the court in the matter of this case shall be the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am.
You may be seated. Please state your full name for the record and spell your last name.
Matthew Ellis, E-L-L-I-S.
Mr. Ellis, good morning.
Good morning.
Scott Bischoff, I represent Mr. Colucci.
Yes, sir.
how long have you been with the Attorney General's office?
2012, September 2012.
Okay. And so were you there when this case was being prepared for trial the first time?
I was employed at, yes,
And what was your role there at that time?
investigator.
And so did you sit in on any of the pretrial meetings when the AG's office was preparing for trial in 2018?
It's very possible that I did.
Well,
Different attorneys asked different times for me to come.
right. And in preparing for the trial today, you would have reviewed your notes from any work at any time in this case, right?
I've looked over the memorandums I've written for this case, yes.
And do you have any notes whatsoever from your involvement in the trial, in the preparation of the trial that took place in 2018?
I don't.
You don't. So does that mean that you would not have been involved in any pretrial meetings?
It does not, no.
It does not.
I mean, I could have been. I'm sure I was involved in some. I just don't know which ones I was involved in.
Well, when might you have been involved?
Sir?
If you believe that you were involved in some, then surely you have a memory of some point in time when you were actually involved, no?
Not that long ago, no, sir, I don't. We've prepped so many trials since, I just don't recall.
And when you prep for trial with the attorneys, the prosecutors, you do take notes, do you not?
Not a whole lot of times I don't. When we hear information that we've never heard before, that's when I write stuff down.
That's the only time that you write stuff down is when you hear new information?
Because we have their reports or their statements that we're typically going through and reviewing what their testimony was, and I normally have those with me.
At a minimum, do you at least record who was present for those meetings?
I don't know. I don't.
So you're telling me that in your role as an investigator for the Attorney General's Office of South Carolina, you don't write down and keep track of who is present in a meeting when preparing for a murder trial?
I don't.
You do not?
I do not.
Is that violation of any policy with the Attorney General?
I know of no policy for that. I write it down when we have information to prepare a memorandum. When we have new information, I put who's there.
What else do you do in your role as the investigator?
Whatever the attorneys ask me to do.
And you're telling this judge that you don't take any notes except when new information comes out?
When we're meeting with witnesses? That's
Yes.
correct.
And your boss is totally fine with you not taking any notes of any of your meetings?
I've never been told that I'm doing anything wrong.
When you have those meetings, are they audio or video recorded?
Not to my knowledge.
Well, you're present in the meeting. Can you think of any time that the meeting has been audio or video recorded?
No, sir, but I don't control the rooms that we meet in at facilities. I don't know what they have. I have no idea.
So when you meet, you're saying someone else is involved in the decision-making.
Say that one more time?
So when you do have these pretrial meetings, what you're saying is someone else is making the decision on whether to record what's discussed.
I just don't know of any meeting that's ever been recorded. No, sir.
Well, if someone else has the responsibility of making that decision, as you just said, who might that person be?
I guess the attorneys. I don't.
You're guessing?
I've never heard of us recording a pretrial meeting of a witness.
Not just audio, video, notes, documented notes on what people are saying during pre-trial meetings. Who is responsible for issuing that directive of who takes notes?
I'm not sure. I've never heard of anyone putting out an order that you have to take notes or you don't have to take notes.
Do you know if the prosecutors that are involved take notes?
If they do, I'm not sure.
You
They
don't
do
know?
just like they have, excuse me.
So go ahead.
Yeah, they have, like I said, when we have new information, we clearly write down information that we don't have so we can turn it over. We always have statements. In this case, you have transcripts, statements, incident reports.
So you're saying that the only time that you take any notes is when somebody gives you new information?
During pretrial meetings, yes, sir.
What about when you're in the field conducting interviews?
Yes, I have taken notes in the field conducting interviews, and then I turn them into, if I take notes like interviewing someone, then I would memorialize that.
What happens to your notes after you're done memorializing?
I discard them.
You discard them.
Yes, sir.
You don't do anything to save and preserve your notes.
No, sir.
When do you write those memorandums after your meetings?
As soon as I get back to the office.
And then the Attorney General allows you as the investigator to shred and delete your notes from interviews. That's permissible?
That's what I've always done.
And the Attorney General of South Carolina knows that you do that.
I've never had a discussion with him about it.
These prosecutors who have an obligation to record information that could be favorable to the defense, you're telling me they allow you to shred your notes after you meet with a witness?
It's either memorializing a statement or a memorandum, yes, sir, and then I discard my notes.
Your testimony today under oath is that the only time you document new information, or I'm sorry, the only time you document information is when it's either new or you're interviewing a potential witness?
Yes, if I don't have any information, then I don't document it.
Well, you document other work that you do you not? It's not just meeting witnesses.
Right, like search warrants, or is that what you're referring to?
I'm referring to anything that you do. Any work that you do. Earlier you testified.
Sure, like in this case, I got search warrants. When I would go get the search warrants, if a magistrate signed, sometimes I can't read their names for signatures or different things. I will write down their name, and then so when I go back and make my memorandum, I will have a clear spelling or whatever of their name.
So you can remember what actually took place regarding that part of your investigation, correct?
Sure, so I can memorialize it.
Do you have any documentation whatsoever of any meetings with Barbara Moore as in your role as the investigator for the Attorney General's office?
No, sir.
Investigator Ellis, listen to my question, please, sir. Do you have any memorandums?
Memorandums, yes, sir. I didn't hear you say memorandum. I apologize. Sorry.
And one of those memorandums is from your meeting with Barbara Moore in February of 2023, is it not?
Yes, sir.
Are you familiar with that memorandum?
Yes, sir.
Did you review it before you came to court today?
A couple days ago, yes, sir.
Did you review it perhaps when Barbara Owen told you that she told David Owen some 10 years ago that Sara told her she would hang herself?
So, say that one more. Did I review it?
Did you review it a few days ago?
Okay.
On June 10th, when you had a pretrial meeting with Barbara Moore?
I did not review it then. No, sir.
You didn't refer to your meeting with her in 2023 after you met with her June 10th?
I don't know if I understand the question. I'm sorry.
Well, on June 10th, and maybe I'm not asking it correctly.
Okay.
I apologize.
Yes, sir.
On June 10th, you had a meeting with Barbara Moore.
Correct.
And people who were present, according to your memorandum, were Joel Kozak, Kinley Abbey,
Yes.
victim advocate Tricia Allen,
Yes, sir.
and yourself.
Yes, sir. That's correct.
And at that time, Barbara told you that David Owen was fully aware that Sara had told Barbara of her plan to hang herself.
Yes, she told us that she had told David Owen that information. Correct.
On another occasion, you met with Barbara Moore doing pretrial preparation, did you not?
Yes.
When was that?
Is that February 23?
Correct.
Yes, sir.
And you also documented that meeting, February 16th, 2023.
Yes, sir.
Do you remember that?
Yes, sir.
What took place at that meeting?
We were in a room meeting with Barbara. They were going over her testimony, the expected testimony or questions and stuff. And during that meeting, Barbara made that statement about Sara Lynn in the garage, upset, and said that she would, if it wasn't for the kids, she would hang herself. And I vividly remember us three looking at each other because we had never heard that information.
Us three being who?
Joel, Kinley, and myself. It was an immediate reaction.
There was not a victim advocate present?
I don't recall. I would assume, yes, there was. I don't recall.
Any particular reason your memorandum from that February 16th, 2023 meeting doesn't say who was present in the meeting?
No, sir.
Do you always take notes like this? Or issue memorandums like this where you don't fully document who's present?
No, sir. I mean, I'm sure there's times that I haven't documented everyone that's present.
On something as important as this, you would not document who was present.
I know Joel and Kinley and myself were there, and I believe the victim's advocate was there because we were with Barbara, who was the victims of the family.
Who was the victim advocate that was there?
I think back in that time it was Vanessa. I believe she was still, she was on this case and she was still employed with our office at that time.
And you're just remembering that from over 2 years ago.
I know she was the victim's advocate on the case, and she just recently left a year or so ago.
And you have no notes from that meeting either?
I took the notes of what Barbara said and then memorialized it, yes, sir, and I don't have handwritten notes, no, sir.
So in your memorandum, there's information that Barbara said that she was crying, Sara was crying,
I believe so, yes, sir.
and very upset.
Yes, sir.
And if it wasn't for the kids, she would have hung herself in the garage.
I believe that was her statement, yes, sir.
That Barbara said she told Michael they needed to take her to the hospital
Yes, sir.
and that she would pay for it.
Yes, sir.
So concerned that she wanted to take her to the hospital. Correct?
That was her statement, yes, sir.
But yet she had the confidence not to because Michael said he would help her. Correct?
I assume that was her. I don't know what she was
Well,
thinking.
did you ask Barbara if she actually took Sara to the hospital?
She said she didn't, that Michael would handle it.
You would agree there's nothing about Barbara remembering on that date that Sara said, "Mom, I wouldn't do it. I'm just kidding." That's not in your memorandum.
Well, I don't recall that, no, sir.
You don't recall hearing it because it was never said, correct?
Sure. It wasn't something new that I had to turn over, so I don't believe I heard that.
You don't think it was important to fully document this new information?
I documented what she told us at the time
Okay.
in the memorandum so we could turn it over. Yes, sir, that's what I did.
And you did the same thing on June 10th, 2025, when you met with Barbara Moore again, correct?
Yeah, there was one completed there, yes.
You documented what Barbara told you.
About telling Agent Owen at the time, yes.
And those notes are shredded. Even from June 10th, we don't have any notes of that meeting.
That was in person. I don't know if I took notes on that because it was just her saying that she told David Owen in her kitchen.
Well, it's new information.
Yes, sir, that's why I memorialized it so we could turn it over.
And you said you took notes when you would do interviews, especially when new information came out, correct?
Yes, sir, I could have. I mean, it was just a one-line sentence.
But because you shred your notes that quickly, we don't have any contemporaneous proof of what you wrote down. Right, we have to take your word that this is the complete information in this memorandum.
Yes, sir, I didn't receive anything else
Certainly
that I'm
there-
withholding from you. No, sir.
I understand.
I'm
Certainly
not
there were-
withholding any information from you.
Well, you are because you shredded notes, but we can address that later. You would agree that your memorandum says nothing about Barbara saying Sarah said, "I'm just kidding." Mom,"
Correct.
Because she never told you that.
I did not hear that. Yes.
Thank you, court's indulgence, Your Honor.
I'm not clear on this. Who is Kimberly?
I'm sorry?
Did he mention the name Kimberly? Who is that?
Kim Lee.
Oh,
me.
Kinley. Oh, I'm sorry. Okay. And this was back in February of 2023? Or were we referring to the meeting 2 weeks ago, or a week ago? The 16th?
I guess we'll have to ask Investigator Ellis.
Okay.
I believe his testimony, Mr. Ellis, correct me if I'm wrong, but you're saying that Ms. Abbey was present for the February 16th, 2023 meeting with Ms. Moore, correct?
That is correct.
And you're also saying that she was present for the June 10th, 2025 meeting.
Yes, sir.
Is that correct?
Yes, sir.
Does that answer your question?
Yes.
Judge, what I'd like to do is approach the witness, and what we can do is make court's exhibits of these memorandums.
Okay.
May I approach it? See if you can look over those documents.
These are the memorandums I prepared.
Okay. All three?
I prepared all three of these. Yes, sir.
Your Honor, this time I'd like to make the memorandum from February 16th, 2023, Court's Exhibit Number 1. The memorandum from June 10th, 2025 as Court's Exhibit Number 2. And the memorandum from June 11th, 2025 as Court's Exhibit Number 3.
May I see those?
Yes, sir.
All right, and so you're saying, according to this memo you wrote, it doesn't list who was at the February 16th, 2023 meeting. you say the South Carolina Attorney General's office met with Barbara Moore on 2/16. But you're saying it was these two people? Mr. Kozak and Ms. Ady?
Correct.
Were there? Okay. All right.
And the victim advocate, correct?
Yes.
And who was the victim advocate? What was that name?
Vanessa.
Okay. Vanessa what?
Woodbury? Was that, I think it was Woodbury. I might be wrong.
What?
She got married. I can't.
Your Honor, victim's advocate is Vanessa Woodbury. She got remarried as Vanessa Payton.
Sorry.
Okay. All right.
Now, on June 11th, Mr. Ellis, you had a phone call, correct, with David Owen?
Yes.
And if at any time you need to see your memorandum, I can give it to you. But this was just some 6 days ago.
Yes, sir.
Did you shred the notes from that telephone call too?
I don't think I took notes from that telephone call.
Didn't take notes.
No, sir.
Your testimony today is that you had no reason to believe David Owen was aware of Sarah's suicidal statement at any point in time over the last 10 years. Is that what you're saying?
What I'm saying is we found out about it
Uh-huh.
in February of 23 when Barbara told us.
Are you familiar with the government's obligations under Brady?
Yes, sir. That's why I documented that so we could turn it over to y'all.
But you didn't take notes on that telephone call with David Owen?
They were doing their pretrial stuff, and the question was asked because of what Barbara had told us, if he knew about that.
He was the lead investigator in the murder case that's being prosecuted this week, correct?
Yes, sir.
And he had been the lead investigator for almost 10 years, correct?
Since he was assigned the case. Yes, sir.
And Barbara Moore tells you that Sara Colucci told her days before her death, by hanging, that she was going to hang herself, correct?
Correct.
And you don't take notes on a telephone call with a lead investigator about that information?
The phone call with David Owen six
Yes, sir.
days ago?
Yes.
I did not. No, sir.
During that call, David Owen told you that he also never took notes when he got that information, correct?
I believe that's what he said. He didn't document it, I believe. I don't know if he said notes.
He never documented that information anywhere.
Right. I believe he said he got it. It was a phone call, he thought.
And he was just trying to remember as well. He doesn't know when he got the information, correct?
During one of their many calls, I think is what he said.
Did anybody take notes when y'all were talking to David Owen?
Not that I know of.
And he told you that he doesn't recall Barbara telling him at her house, but it was during their, quote, many phone calls?
He stated that it was, that's correct, that it was during he thought it was during one of their phone calls.
Did you ask him why he didn't document that information?
I didn't ask him why he didn't document it.
Do you remember Joel Kozak asking him why he didn't document that information?
I believe David just said that he didn't document, he didn't know why.
And that was an okay answer for you?
Well, at this point, it's just the information that we have.
Yes, sir. 10 years later. It's never been disclosed for 10 years. You understand that, correct?
Yes, sir. I just gave you the information that we received.
But it did not concern you that David Owen never documented that information.
At this point in time, I have no control over that.
Well, you have control over what you document, correct, sir?
And I turned it over to you.
Did Miss Abid, Kinley Abid, did she document?
I don't know.
She didn't write any notes either.
I don't know, sir.
Did she ask David Owen why he never documented that statement?
I think David Owen told us that he didn't know why he didn't do it. I don't know if there was a question about that. I think he gave that forthcoming when he was asked about it, that he didn't know why he didn't document it, that he remembered her telling him the information.
Thank you. No more questions.
Cross.
Yes, Your Honor. Investigator Ellis, I want to clarify what your role is with the Attorney General's office and what your role is in this particular case, okay?
Okay.
Is it fair to say that you are not a front-end investigator on cases?
Correct.
Okay, when I say that, I mean you're not out there responding to calls, making arrests, right?
Correct.
Okay, that specific person in this case is ultimately David Owen, right?
That's correct.
Okay, so what you do is you help as a secondary support for the attorneys in the Attorney General's office, is that right?
Correct.
So as we're preparing cases and going through cases, you help us gather and arrange things that we may not have, right?
That's correct.
And so part of that is when we go to meet with witnesses, to witness prep, you attend some of those meetings with some of the attorneys, right?
Sometimes I do, yes.
And the reason why you do that is in case a witness says something that they hadn't previously said, we have you turn over a memorandum, right?
That's correct.
And this allows for you to testify to those meetings as opposed to maybe me and Joel, right?
Correct.
Okay. And so in this particular case, you weren't the front-end investigator, right?
No, ma'am.
You got brought in as it was getting prepared for trial in 2018, right?
I believe that's correct, yes.
And even I think there was a witness that you even went and interviewed in 2018, Philip Davis, right?
Correct.
Okay, and you memorialized that interaction, right?
Correct.
Okay, and that was turned over to the defense prior to the first trial, right?
Correct.
Now, in this particular case, or in any case, when you're meeting with us, at the end of those meetings, the attorneys will frequently tell you, hey, that's new information, we need you to create a memorandum, right?
That's correct. There's cases that I don't know every witness statement and testimony.
Right, but typically for us, we already have the incident reports, right?
Yes.
We have previous statements, right?
Correct.
We have any of the other case file in full, right?
Yes.
Okay. So what we're specifically listening for in those meetings is any sort of new information, right?
Correct.
And in 2023, in February, you attended a meeting with Joel and I and a victim advocate, right?
Correct.
Okay, and this was of Miss Moore, right?
Yes.
And in that meeting, Miss Moore then told us that that Sarah had told her that if it wasn't for the kids, she would have hung herself, right?
Yes.
Okay, and that is something you memorialized, isn't it?
Yes.
Okay, and that meeting was on February the 16th of 2023, and that was then subsequently turned over to the defense right around that time, right?
Yes.
Okay, so that is more than 2 years ago the defense had that information from Miss Moore, right?
Correct.
Okay, and you're familiar with this case, aren't you?
Yes.
And you had the opportunity to sit through a lot of the first trial in the case, right?
Correct.
Okay, and the idea that Sarah was suicidal, that wasn't something that was hidden, right?
I don't believe so.
There were text messages, weren't there?
Correct.
Text messages that were referenced previously, right?
Correct.
Okay. And that's information that was brought out, right? The allegations in the first trial was that it was either an accident or a suicide by the defense, right?
Correct.
So the idea that Sarah was suicidal or depressed or committing suicide, that isn't new at all, right?
Correct.
And you had an opportunity to sit with us throughout pretrial motions in this case several weeks ago, right?
Correct.
Okay, and throughout that, do you remember the defense filing the motion of admonishment?
I do.
Okay, and in that motion, what they wanted to do was to have David Owen admonish Barbara Moore or correct any lies that Barbara Moore had said previously. Do you kind of remember hearing anything about that?
Vaguely, yes.
Okay. And so in preparation for that motion and for this trial, we met with Barbara Moore again on June the 10th of 2025, right?
Correct.
Okay, and throughout that meeting, you were present, right?
Yes.
The victim advocate was present,
Yes.
and Mr. Kozak and I were present, right?
Correct.
And in that meeting, we were addressing with Barbara things that were in her written statement or were not in her written statement versus things that she was testifying to or saying. Do you recall that?
Yes.
Okay. So, for instance, one of those things was her saying that Sara Lynn told her that day that she was going to leave Michael on Saturday. Do you remember us addressing that?
I believe so.
Okay. And then also one of those things was this hanging statement in the garage, right?
Correct.
Okay, you were just sitting in here when I asked Ms. Moore whether or not she included that hanging statement in her written statement, and she said no. Do you remember hearing that just a few minutes ago?
I do.
And so then when she said that it wasn't in there, we asked why. Do you recall during that June 10th meeting?
Yes.
Okay, and that's when Ms. Moore relayed to us that she knew that she had told David Owen, right?
Correct.
And when Ms. Moore left that room, we asked you to memorialize that, right?
Correct.
And so you drafted this memorandum on June the 10th, didn't you?
Yes.
We have the opportunity to review it and make sure it includes everything that was said, right?
Correct.
Okay, and then we turned it over to the defense, right?
That's correct.
Then the very next day, in preparation for this trial, we were talking with David Owen, right?
Yes.
Okay, and you were present, right?
Yes.
Mr. Kozak and I were present.
Correct.
And this was over the phone, wasn't it?
It was.
And in that, we told him that we had spoken with Barbara Moore and that she had said that she knew that she had told him, right?
Yes.
Okay. And in that statement, he said, I know that she told me, I just can't find where I wrote that down anywhere in my report.
Correct.
And at the end of that meeting, we wrote the memorandum, right?
Yes.
And we immediately turned it over to the defense, right?
Correct.
And is that kind of what your role is to help fill in those gaps when we discover new information throughout the course of this trial?
Sure.
And it wasn't just these memorandums that you've prepared, right? Not just these Barbara and David memorandums, right? Throughout this case, you've been with us while we've prepped other witnesses, right?
Sure.
So for instance, Philip Davis, right?
Yes.
And you wrote a memorandum, right?
Correct.
And we turned that over to the defense, right?
Yes.
Is that kind of the normal practice for us in this office?
When we receive new information to
Yes,
turn
sir.
it, yes.
Your Honor, may I have 1 second? I have no further questions for Investigator Ellis.
Let me clear something up. I got a question. You said the February 16th, 2023 meeting, you and Mr. Kozak were at that, and that got memorialized. And you said, and that was turned over to the defense?
Yes, sir. This February 16th, 2023 memorandum,
When was that turned over?
day after, in 2023. It was because, Your Honor, that was for preparation of the upcoming trial on March 6, 2023. So when we received that information, we memorialized it. That was turned over in 2023 prior to that March 2023 date.
Well, then why did it appear that it was new information just 10 days ago?
It's not, Your Honor. I believe what they're saying is the new information is that David Owen Barbara said that she had told David Owen that back in 2015. We asked David Owen, he said, yeah, I just don't see where I put it in the report. So the suicidal statement is not new information. The fact that David Owen knew it is what they're saying is the new information. But this statement was turned over in 2023, more than 2 years ago, Your Honor, and they've had it.
All right. Do you have any redirect?
Judge, I don't, but I'd just like to briefly respond to what she just said. That is why he memorialized it. It's because the new information is the fact that David Owen, the lead investigator, has had it since 2015 and never turned it over. That is the new information, not just the statement, but the fact that the government was in possession of it for that long and never told the defense or seemingly anybody else.
But they told you in 2023.
Judge, our position is that the Brady violation doesn't take place until there is proof that the government was in possession of that information. If Barbara had it and never told anybody about it, that's one thing. And even when she told them in 2023, that perhaps is another thing. But now the new information from a few days ago is that David Owen, the lead investigator, had the information.
Okay.
And I have no more questions for Mr. Ellis.
All right, you can step down.
Recall David Owen.
Tell you what, I'd like to take a restroom break. Let's take 10 minutes. And we'll be back shortly. All right, Mr. Bischoff, you have, what is Mr. McGuire? Who's calling you? All right, call you witness.
Thank you, Your Honor. Defense calls Megan Burkstead.
Please raise your right hand, place your left hand on the Bible. Do you swear or affirm the testimony you shall give the court in the trial of this case shall be the truth, the whole truth, nothing but the truth, so help you God? Yes, ma'am. Will you be seated? Please state your full name for the record and spell your last name.
Megan Burleson, Burleson.
Good morning, Miss Burleson.
Hi.
I'm sorry that we had to subpoena you on such short notice.
Could you start by telling me your name, please?
No.
Okay. And I don't think you're sorry, but thank you for that. Go ahead.
Okay, I need to ask you questions. You don't get to ask questions.
Oh.
You are an attorney, right?
I'm aware, yeah. I think it's polite to tell me who you are, but go ahead.
Okay. Well, I started with an apology, and I was getting to that before you interrupted me. So I am sorry that we had to subpoena you on short notice.
Actually, you didn't have to on short notice. I think you knew and you could have done a little bit better, but thank you again. Go ahead.
Can you tell me what you mean by that?
I think you probably knew for quite some time you needed my
Ma'am,
testimony.
Ma'am, let me stop you.
Yes, sir.
Answer the question. Do not go where you think you're going on this, or
Yes,
you
sir.
will find yourself in contempt of court. Do you understand that?
I do, Your Honor.
Stop editorializing. Answer the question.
Yes,
That's
sir.
your warning. Don't do it again.
I understand, Judge. I thought I was being responsive
Stop.
to the most recent question.
Answer the question.
I'm happy to, Judge.
So we just, and I don't know how much communication you've had with the prosecutors about the issue that's come up and why we had to subpoena you.
I don't know the issue that's come up.
Okay. So you prosecuted the case against Michael Colucci in 2018?
Correct.
Okay. And David Owen was the lead investigator
For SLED, yes.
for SLED. And have you learned that David Owen was in possession of information that he got through an interview of Barbara Moore, where Barbara Moore told him that Sara made the statement 2 weeks before she passed that if it wasn't for the girls coming home, I would hang myself in this garage?
I don't know what you mean by learned. I received a phone call from the prosecutor, Joel Kozak, asking me something along those lines, and I was shocked. So I don't know what you mean by learned. I have not been given detail, and I've certainly not talked to anybody at length about it.
Okay. So the first time you heard this information was from Joel?
Correct.
Okay.
That specific statement, yes. And I would not say he gave all those details. I don't remember the full extent of our conversation.
Okay. Well, so you're not aware that David Owen in 2015 knew that Sara said 2 weeks before she died that she would hang herself in her own garage?
I don't know what he knew, but I certainly never talked to David Owen about that.
Okay, he never told you that?
No. If he had told me that, I would have been shocked, and that's something we would have turned over.
Okay. So in preparation for trial in 2018, you would have met with Ms. Moore.
Sure, I'm sure we met more than once.
Of course. And she told you about a day, about 2 weeks before Sarah's death, that she went over to Sarah's house. Do you remember that?
I do not remember that.
Do you remember in her direct examination asking her about that day?
I do not remember that.
Okay. If I could have 1 second, Judge. I want to show you just a snippet of your direct examination of Barbara Moore, and then I'll ask you some questions about it.
Okay.
What was her demeanor?
She had cried until her face was just swollen. I said, oh my gosh, but honey, what's the matter? She was sitting in the chair.
Let's not say anything that she said.
Okay.
It's all right. Take a minute. Just describe how she was acting. Did she appear upset or happy?
She was very upset. She was crying. Her face was all swollen.
Did you get an understanding in that interaction with her of what was upsetting her?
I did not. What I said, honey, what in the world is the matter? And she just said, Mommy.
Don't say anything that she said.
Okay.
So following this interaction with her, did you, how did you feel?
I was very concerned. I felt like that Sara Lynn needed to go, she needed some help because, and I felt it was her drinking. I really did. There was an open beer can on the table beside her. And
so you wanted to get her help?
I wanted to take her to the hospital because I felt like she needed help.
Okay.
For drinking. She needed alcoholic help.
All right.
And it wasn't.
Did you, and is this the Wednesday prior to her death or 2 Wednesdays prior?
This is 2 Wednesdays prior.
So approximately 2 weeks before her death?
Right.
All right. So did you see Michael that evening and at that
I did.
time? Okay.
He came home. Really, I had not been there very long when he came home. And she was, I mean, he saw how upset she was and crying she was. And
did you tell him that you wanted to get her some help?
I did.
And what was his response?
He asked me to, he said, if you'll just pick the girls up from school, Barbara, and take them home, let them spend the night with you tonight. He said, I can calm her down. She's upset because Camilla, which was his first wife, had called, and I don't know what that was about. But the reason she was upset was because of this interaction. And he said, I can calm her down. I did exactly what he asked me to. I picked up the girls from school. I took them home. They spent the night with me. I called him, and she was calmed down. I spoke with her the next day. She was fine. I talked to her about...
Well, just, let's get a stopping point. So you didn't actually take...
So, do you remember that now?
I saw what you saw. I don't remember it in vivid detail, no.
Okay. Well, you stated several times, don't say what Sarah said.
Right. That would be hearsay.
What would, if Barbara was allowed to answer that question, you didn't stop her, what was she going to say?
I do not recall.
I mean, you'll have to... So when you asked her those questions, and you're very careful, don't say what she said, don't say what she said.
Right.
Are you aware of the fact that really the only thing Sarah said to Barbara on that day is that if it wasn't for the girls, I would hang myself in this garage?
No, I do not recall that. What I recall is trying to be careful because I do follow the rules. I'm trying to be careful not to mistry a case by having hearsay, and as I recall, there was some discussion that we shouldn't get into drug usage and things like that, which I think is why she was talking about alcohol. That's all I remember. I wouldn't ever get into what someone said outside of court. Beyond that, I don't recall.
So obviously you had a conversation with Barbara Moore about that day that she described, Sarah being upset, crying, right?
I must have, yeah.
I mean, it would, of course, you're an
Prepare
attorney.
trial, right.
You're gonna prep for trial.
Sure.
And you're gonna ask her questions about, well, what did Sara say? What was going on? Give me all the information you have about that day. You would have asked those questions.
I would assume, yeah.
And she would have told you, what she said was, if it wasn't for the girls coming home, I would have hung myself in this garage. She would have told you that.
I do not recall that. The first time I heard that was when Joel Kozak called me last week, and I don't even remember all the details, but I was floored when he called me last week and said that.
Okay. I'm gonna get you to watch a little bit more of the director, Barbara Morgan. Yeah, if you can just a second.
Do you know if she was working much at the time of her death?
She was not.
Why do you think that?
The understanding that I have is that she and Michael had had some kind of a altercation or argument at the jewelry store. And she said she was never going back there. She would never go back and work.
So that would be a hearsay statement, right?
Well, I'm only half paying attention to what she's saying there because I'm confused about where this line of questioning is even going. But that would be more of an action that they would go someplace. I think that was her actions, that she went to the jewelry store.
Well, she said she was not going to go to the jewelry store
Okay,
anymore.
that's an action.
So that is a hearsay statement, no?
No, that's not for its truth necessarily. It's an action. What she was physically going to do, a state of mind.
Okay. So,
Sure.
So when you were prepping Barbara Moore, you were okay with her saying some things Sara said, but not the part about the hanging.
I don't recall anything about a hanging, sir.
Why didn't you admonish her? Don't say what Sara said in that exchange.
Well, probably in that moment, I kind of gave up or it wasn't necessary in that moment. I don't know. We all know they went to the jewelry store. That wasn't some big secret. I don't know. I can't tell you what I was thinking 6 years ago. You have the transcript. Presumably, you know more about it than I do at this point. And in fact, I would assume you have everything that the Attorney General's office has needed to turn over to you, which would have been my notes,
Well,
to the extent necessary.
well, let's go to the conversation you had with Barbara Moore preparing for the 2018 trial.
Which conversation?
The one where she mentioned Sara crying and her face being swollen, her eyes puffy. Can you remember that conversation?
No.
At all?
Any notes I would have would have been left with the state's file.
Well, you would have, obviously, if she tells you 2 weeks before she passed, she was terribly, terribly upset at her house that she, Barbara Moore, went to the house, found Sara alone in the middle of the day, drinking, crying to the point where her face was swollen. You would have wanted to get all the information possible about that incident, right?
Presumably, I vaguely remember that. Again, any notes I would have taken would have been left with the state's file. No one prepared me for this testimony today, so.
Well, we've established that the Attorney General's office doesn't actually take notes of everything, and it's kind of a habit. So I don't have a lot of faith that you have those notes in that file.
I couldn't tell you what's in that file. I haven't seen that file in years. I can tell you that I follow the rules, and if someone had said something like that, and it was given to me or told to me, I would have turned it over.
So you said.
Correct.
That's all I have for you, ma'am. Sorry about the short notice on the subpoena.
Thank you.
Any cross?
Briefly, Your Honor. Ms. Burleson, I want to kind of catch us up to where we are today, okay? When did you get sworn into the bar?
The South Carolina bar?
Yes.
Gosh, I guess 2002, maybe? Yeah.
And
May of 03? That sounds right.
And
Yeah.
for the majority of your career, you've practiced either as a public defender or as a prosecutor, right?
Correct.
Okay, and you were a prosecutor with the Attorney General's office, right?
Yes.
For about how long?
15 years.
Okay, and when did you stop working at the Attorney General's office?
August of 22.
Okay, and during the first trial of Mr. Colucci, you were the lead prosecutor on the case, right?
Yes.
And I believe you tried the case with Mr. Kozak.
I did.
And then when you left in 2022, Mr. Kozak took over the case, right?
Yes.
And then I got brought in afterwards to assist with it.
That's my understanding.
Okay. And standard procedure-wise, when you go to meet with witnesses, that's not something you do by yourself, right?
Correct.
Okay, you typically bring co-counsel?
I always bring some sort of witness, an investigator, co-counsel, somebody. Correct.
And what's the purpose for bringing a witness or someone else with you?
There's lots of purposes.
Okay.
For one, to not make myself a witness if something comes out. Number two, if something comes out that needs to be turned over, there's another witness to memorialize it and turn it over. Number three, to help me make sure I don't miss something. Or maybe, and number four, maybe they have ideas or something that needs to be fleshed out further just to kind of facilitate in preparation for trial.
And so you stated that one of those reasons was that if some new information was turned over, you have somebody there to memorialize it for you. Is that fair?
Correct.
Okay. And if Barbara Moore would have told you in preparation for this trial that Sara had made a statement that, but for the kids, she would have hung herself, you would have turned over that statement.
I would have turned it over. I would have had it memorialized and turned it over.
Because that was something that you didn't know from the case file, right?
Correct.
Okay. However, you did know from the case file that she had made a suicidal statement previously via text message, right?
I recall some suicidal statements and just general depressive states and some letters and some things along those lines, yes.
And that's something you learned from the case file in the very beginning, right?
Yes.
And that would have been 2016, right?
Whenever I got it, yes.
Okay, and that would have been turned over to the defense way back then, right?
Yes.
And in fact, in the first trial, there was some reference and mention of her depression and prior suicidal thoughts, right?
That's my recollection.
Now, when talking about this specific trial, Judge Jefferson presided over that trial, right?
Yes.
Okay, and throughout that trial, she set parameters on what you could and could not talk about, right?
Definitely.
And you just referenced a little bit of that with Mr. McGuire, that one of those things is drugs, right? That she wasn't going to allow you to talk about some drug usage.
Correct.
And another one of those was hearsay statements, right?
Yes.
Okay, and as a prosecutor, as you're questioning a witness, in order to avoid those landmines, those mistrial landmines, a lot of times you may lead them around it, right?
Correct. You try not to elicit the improper information.
And a lot of times you may even cut them off, right?
Correct.
Okay, and you do that to make sure that the jury doesn't hear information they're not supposed to hear, right?
Yes.
Okay, and I believe we've seen some clips in here of you doing that with Miss Moore, right?
Apparently, yes.
Okay,
And
you-
we just saw some.
Right,
Yes.
you stopping her before she says anything Sara Lynn says, right?
Yes.
Okay, I'm also going to approach you with this transcript and flip to page 718. Okay, so that's 718 on top, right?
Yes.
And when it says question, you're the individual asking the questions, right?
Presumably, yes.
Okay, and this is Miss Moore's transcript. Sorry, I should have clarified that for you.
Then yes, I did her direct.
So then the answer would have been from Miss Moore, right?
Yes.
And so then on page 718, line 22, you say, let me back you up. Don't say what she said. Just give me an understanding of the land deal. Okay, you're not talking about the conversation in the garage that day, right?
Again, I don't know. I don't remember anything about a garage, but I have no idea what I'm referencing. Presumably not that.
Okay, but in line 23, you say, just give me an understanding of the land deal, right?
Correct. Trying
Okay.
to stick to pertinent information that's not prohibited.
Okay,
Yes.
so that conversation when you cut her off is about presumably a land deal, right?
Yes.
Okay, and you stop her from saying what Sara Lynn had said, right?
Correct.
Okay, so the times that you stop her or prevent her from saying what Sara said isn't just related to 2 weeks prior to her death, right?
Correct.
Okay, then if you can flip to page 732.
Okay.
And I'm going to look at line 17. You say, okay, without getting into anything that Sara said, when was the last time you talked to her? Okay, that's referencing a different conversation as well, is it not?
It appears to be. I would think so. Yes.
Okay, and you again direct the witness not to specifically say anything that Sara Lynn said.
Correct.
And that's something that you would have done throughout the course of the trial with any witnesses that may have been providing information that the judge deemed not admissible. Is that fair?
To the best of my ability, yes, that is fair.
Okay, and you stated earlier that you never had any conversation with David Owen about this hanging in the garage or the fact that she wouldn't hang herself because of her kids.
I definitely do not recall that.
In
no.
fact, you stated that the first time that you ever heard this was from Mr. Kozak, right?
I was shocked
Okay, and that conversation with Mr. Kozak was just last week, right?
and extremely short, yes.
And so that was presumably when we came into possession of that information about David Owen.
I don't know when he came into possession of it, but he asked. He said it had come up in court.
And
And
that
he
was
had
last
asked
week?
if I was aware, and I was shocked.
And that was last week.
That was last week.
Your Honor, I have no further questions if I can approach and retrieve the transcript.
Nothing further, Judge.
You may step down.
Thank you, Judge.
Defense will call Ed Langford.
She's under subpoena. Do you need her for anything else, or is she released?
We can release her.
All right, you're free to go.
Thank you, Judge.
And again, Judge, that was Ed Langford's next witness.
Please raise your right hand. Do you swear or affirm the testimony you shall give the court in the matter of this case shall be the truth, the whole truth, nothing but the truth, so help you God?
I swear.
You may be seated. Please state your full name for the record and spell your last name.
Edward Langford, Langford.
Ed, you and I know each other.
Yes, we do.
I'm one of the lawyers representing Michael Colucci, and you've been the investigator on the case for us.
Yes, that's correct.
And you've done a number of investigative tasks in this case.
Yes, I have.
And most recently, that included serving a subpoena on Miss Megan Burkstead, named now Burleson.
That's correct.
And where did you serve her?
I served her at a residence in Columbia.
Okay. And when you went to the residence, did you knock on the door?
I did.
Was a car in the driveway?
It was parked out front.
And it was your gut feeling that she was home?
I felt her, there was a strong possibility that she was inside the house, yes.
Okay. And you knocked for a little while because no one answered the door.
Correct.
And after knocking for a while on the door, did you leave the residence?
I did. I just went down the block and turned around, and she was kind of set up a surveillance, better to speak, to see if anyone's going to come or go. She's going to arrive home or she's going to leave.
Okay. And did it turn out that she actually was home?
Oh, yeah, she was home.
And she was just refusing to come to the door?
I think so, yes.
And were you knocking loud enough where a person in the house would hear you knocking?
Clearly, yes.
Okay. After she refused to answer the door and come to the door to be served, and you went down the street, did she reappear?
Yes.
What was she doing when she came out of the house?
It was about 8-10 minutes later. I saw her front door open. She came out, large handbag over her shoulder. She had a dog on a leash, and she briskly walked to her car.
Okay. So she was moving fast to the car?
Oh, yeah.
And were you able to catch up with her?
I was. I was able to get down the block before she left and kind of park right near her, right next to her.
Okay. And to serve her, you have to identify that she's the right person.
That's correct.
And did you call out her name?
I did.
And what did she do?
Well, she was on the other side of the car at first, so I didn't want to frighten her, so I just let her know, hey, there's somebody on this side. I said, hey, Ms. Burleson. And she came around, and she clearly knew who I was because she had the look of anger on her face as she came around. And
did she say anything to you?
oh, yes. Yeah, she
What
did.
was her demeanor?
She was very, very angry.
About being served?
I believe so.
You were able to effect service on her?
I was.
And before being a private investigator, I mean, you have experience in criminal investigations, obviously.
I do.
And you own your own company, Tracker Investigations.
For the past 29 years, yes.
Okay. And in your experience in working on criminal cases, Did all facts point to Miss Burleson trying to evade service?
That would be,
Objection, Your Honor. That's speculation.
Nothing further. Thank you, Judge.
Sister, do you have any questions?
Oh, I've got one more question. Sorry, Joe. It'll be a second. I asked you, did she say anything to you? And we established what her demeanor was. What did she say to you?
well, after I told her who I was, and I had the subpoena in hand, I said, hey, we met a few years ago. I've been asked to give you this subpoena. And she said, are you the guy that was knocking on my door like a motherfucker?
That's all I have for
That's
you.
it.
Thank you.
Cross,
Nothing, Your Honor.
you can step down. Next witness.
David Owen.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
You do? Please state your full name for the record and spell your last name.
David Owen, O-W-E-N.
Mr. Owen, you were no longer with SLED, is that correct?
That's correct. I retired June of last year.
And you had just started with SLED maybe approximately 2 months prior when you got assigned this case, is that correct?
That is correct.
And you primarily worked out of the Lowcountry office.
Yes, sir.
And correct me if I'm wrong, but the Lowcountry office is in Colleton County.
That is where the office is based, correct.
So even though SLED's main headquarters is up in Columbia, you would report to Colleton as your office.
Correct.
You did not report to Columbia every day.
No, sir.
And there were other agents in that Lowcountry office with you, correct?
Yes, sir.
Do you remember the names of some of those agents?
Who worked with you?
Give me just a minute, sir.
Sure.
Richard Johnson, Katie McAllister, Teresa Beecham, David Williams, Bobby Bancroft, Ryan Kelly, Natasha Morrell, Jomar Albayalde, and I believe those are all the agents. I may have missed one or two.
No, it's okay. One of those agents you mentioned.
I'm sorry, Angela Peterson, sorry.
Okay, no problem. So approximately 10 of you, more or less?
10 to 14.
Okay. And you had support staff as well, but those folks you just named were actually field agents just like yourself.
Yes.
And who was the supervisor?
My immediate supervisor at the time was Lieutenant Charles Gint.
All right. And what was your rank when you just started out with SLED?
Special agent.
And what was the rank of Ryan Kelly?
Special agent.
So you two were basically colleagues.
We worked out of the same office, yes.
You didn't take orders from him.
Correct.
He didn't take orders from you.
Correct.
Okay. And Ryan Kelly's wife actually lived with the Moores her senior year of high school, didn't she?
I have no knowledge of that.
No, you never talked to Ryan Kelly about this case?
The conversation we had is that his wife was familiar with the Moores family and he was not going to be involved, and I said, I don't want you involved. Anytime, it was common knowledge throughout any agent, anywhere in law enforcement, if you have some type of connection to the case, you don't get involved.
When did you learn that he had that close connection with the Moore family?
I believe it was within the first week of me being assigned the case.
And when you were assigned the case, it was a couple of months after Berkeley County had investigated or begun the investigation, correct?
That is correct.
And you took over the case on, I believe, July 31st?
Yes, sir.
And at that time, you actually met with Sheriff Dwayne Lewis. Is
Yes,
that
sir.
right?
Yes, sir.
And he gave you a letter that said we'd like SLED's assistance.
That letter was sent to Chief Keel and then to my captain, Ryan Neal, at the time.
Okay.
And that was the letter of request for us to look into or take over the case.
And the date of that letter, you're familiar with it, I understand.
Yes.
And the date of that letter is July 31st,
Yes.
2015.
Yes, sir.
And so there have been conversations with Berkeley County about you guys taking over prior to July 31st, 2015, correct?
Yes.
And on July 31st, 2015, you inherited essentially a case file from Berkeley County.
Not necessarily on July 31st, but the normal procedure is SLED works on request. It's either verbal or written. So the written request comes in, supervisors assign an agent. I was assigned this case. We have approximately 3 days to contact the requester, whether it's a sheriff, a chief of police, or an individual. So I made contact with Sheriff Lewis and set up a meeting.
And do you have any notes, documentation about the content, context, if you will, of those conversations leading up to July 31st?
Leading up to July 31st? No, sir.
But you did discuss taking over the case prior to then.
I was not involved with that
So you're
decision.
saying that was just SLED, other people involved with SLED?
With me not being a supervisor, my understanding is a sheriff, a chief of police, or someone else request SLED to look at a case, a supervisor would contact them and say, hey, what's going on? And they would decide whether SLED is going to take the case or not. Then an agent is assigned. I have no knowledge other than if it came through an email or if it's written in the letter, what was discussed person to person via phone or email prior to that, other than that documentation.
But you know there were conversations,
There had to be.
correct, right?
Yes.
Had to be. And you're just saying those conversations did not involve you?
That's correct.
They may have involved a supervisor?
Yes.
Any reason that those conversations are not part of your case file?
I don't get notes from the supervisors. They said I talked to somebody, worked this case.
Okay, that would be something from somebody else?
Correct.
Would they have documented any conversations they may have had with Berkeley County
I
Sheriff's
have no
Office?
knowledge of that.
You would agree with me that your report does say, the main investigative report, that on July 31st, 2015, the South Carolina Law Enforcement Division received a written request from Berkeley County Sheriff Dwayne Lewis to assist with investigating the Colucci case.
I do agree with that, yes.
You would agree that's a bit misleading, is it not?
How is it misleading?
Well, that wasn't the first day the request was received.
That is the date on the letter that I received that the request came in.
And in your report, again, one of the first sentences, you said that you typed up, according to Berkeley County Sheriff's Office incident report, which was part of the packet you got,
Yes.
correct? Deputies responded to a possible suicide.
Yes.
So the very first information that you get is that it's a possible suicide.
Yes.
And on that same day, July 31st, 2015, you also received a batch of text messages from Berkeley County, correct?
I'm not saying it was July 31st, but shortly thereafter, I received their case file.
Well, if your report said that you reviewed them on July 31st, surely you would have actually received them on July 31st, correct?
Would you show me what you're looking at, please, sir?
Sure. May I approach?
You bet.
Do you recognize that, sir?
Yes, sir, it's a report of mine.
And what does the first sentence say?
On July 31st, I obtained forensic download reports of 2 Apple iPhones, which were legally obtained during execution of a search warrant.
So you did receive text messages from downloads of cell phones on July 31st.
It's if that's what my report says, then that's when I received them. But I don't review all of them in one day.
Your report then goes on to say, again on July 31st, that you reviewed the reports of Sara Colucci and Michael Colucci's phones and found the following information. And then you list information that you got from those reports on July 31st.
Okay, yes, sir.
One of the calls, actually 2 of the calls that day, were to a Dr. Jenkins' office. Do you remember that?
Yes, sir.
In fact, this is actually on page 2, one of the first 5 entries references those calls to Dr. Jenkins.
Yes, sir.
And Dr. Jenkins is who?
I believe Sarah's psychiatrist or psychologist. I can't remember exactly which one he is.
All right. And so you knew that she had a psychiatrist. First day on the job, you knew that she had a psychiatrist.
I'm not going to say first day on the job, but yes, I knew she had one.
Well, are you saying that we can't be sure when you actually reviewed anything based on your report?
I received the information on July 31st. I received the case file. It is impossible to review every single thing, study it, and learn it within one day. I received it on July 31st or thereabout, and from that day forward, I continued to work the case file and review the case file.
Do you typically put things at the front of your report that you review later? Is that normal?
Can you rephrase the question?
Sure. If information is at the very beginning of your report, some 50 words in, it would make sense that that's something you reviewed first, correct?
There's really no rhyme or reason how the report is put together. It's just documenting what was done.
Okay. You're also familiar, however, with some of the content of those messages.
Yes.
And you know that some of them were pretty explicit in terms of Sara and what she was going through.
Yes.
In terms of her mental health.
Yes.
One of the main exchanges in your report that you highlight, and again, you don't highlight every text message, correct?
Correct.
You put stuff in the report that's important to you.
Yes.
And one of the messages that you highlight are a string of messages with her friend Philip Davis.
Yes.
And you would acknowledge that she pours her heart out to Philip Davis on May 18th, 2015.
I agree.
2 days before her death, she's talking to her longtime friend, Philip Davis, about how hard May is for her.
Yes.
And how it, quote, never gets easier.
I would agree with that.
And how, quote, this is my most fucked up time of the year, just trying to make it.
Yes.
And May 18th has some significance in this case, does it not?
Yes, it does.
And what is May 18th?
I believe it's either the anniversary of the marriage with her second husband or either his death.
It's the anniversary of his death.
Okay.
And do you know how he died?
Yes.
26 self-inflicted stab wounds, correct?
That's what was reported. Yes, I didn't investigate that file.
That's a good reason to be depressed.
Losing a spouse, yes.
Objection, Your Honor. Can we get to the actual Brady violation portion of this?
We are. I will.
Go ahead.
So it was no surprise that Sara had left information in her phone that she was struggling in May.
Yes.
And a few days ago on June 11th, 2025, you were asked questions about a specific, explicit suicidal statement that she made. Correct?
What was the date again, sir? I'm sorry.
June 11th?
Yes.
Just a few days ago.
Yes.
Do you remember that conversation?
Yes, I do.
And during that conversation, the AG's office told you that Barbara Moore said she told you about that explicit suicidal statement during your August 5th, 2015 meeting with her.
Mrs. Moore told me that statement, but it was not during the August 5th meeting.
You don't believe it was during that meeting?
I know it was not during that meeting
How do you know that?
because she wrote a statement. I reviewed the statement, and I even asked additional questions of her that day, and it is not in her handwritten statement, and it's not on the additional statement that she provided.
So you're saying that you were not aware of it on August 5th,
That is correct.
2015. What about during your follow-up thereafter on August 25th?
It was not disclosed to me in August, on August 5th or August 25th.
Do you have any idea whatsoever when you learned of that statement?
No, sir, I do not.
But you remember that it was made,
Yes, I do.
and you remember that it was made to you directly by Barbara Moore,
Yes,
and that she told you that through a phone call,
yes.
one of the many phone calls you had with her.
I had very many phone calls with her and Mr. Moore.
Did you document when you had those phone calls?
No, sir, I did not.
Did you write any reports when you had those phone calls?
A majority of the, no, I did not. The majority of those phone calls were an update on what's going on. A lot of the same information was provided by Mr. Moore and Mrs. Moore that I had already received. So I do not know exactly when that information came through. You mentioned earlier that I was assigned to the Lowcountry, covers 12 counties. We're on the road a lot. That's a lot of the times when we would actually have conversations with any of the victims or anybody involved in the case.
So your standard procedure in investigating cases is to have phone calls with witnesses of in cases as you're just driving down the highway and you never document it?
If they give me new information, however, I did not document this. And I admit that I did not document it.
And you didn't document it despite knowing full well Sara was struggling with her mental health.
I had other information that she had mentioned being suicidal and depressed, alcohol and drug abuse.
A statement about specifically planning to hang herself, and the information you got on day one was that she was hung up in a hose, and you never documented that.
Correct.
Thank you.
Cross?
Briefly, Your Honor. Now, you already stated to opposing counsel that you received cell phone extractions in this case from both Michael and Sara.
Correct.
And you've already stated that those cell phone extractions had what you would say suicidal statements in them.
Yes.
And to your knowledge, those extractions were turned over in the initial discovery to defense.
Yes.
Okay, and so during your investigation, did you go meet with the psychiatrist?
Yes, I did.
And when you met with the psychiatrist, you also got the records from the psychiatrist's office, correct?
That is correct.
And those were turned over to the defense, correct?
Yes.
And you also went and got the the DHEC prescription log for Sara, is that correct?
Yes.
And that would have been turned over as well?
Yes.
Okay. And you never let prosecution know about this statement, did you?
No, I did not.
Nothing further, Your Honor.
Just one follow-up, Judge.
Okay.
You didn't meet with her psychiatrist until after you arrested Michael Colucci. Is that correct?
That is correct.
No more questions, Judge.
Anything?
Nothing to state, Your Honor.
You can step down. Any other witnesses?
No, Your Honor.
Anything from the state?
Nothing for the state, Your Honor.
Okay. What do you want to say about this?
Your Honor, we filed this motion to dismiss for government misconduct on June 13th, 2025, after we became aware that the government had been in possession of clearly Brady material for 10 years and never disclosed it. Your Honor, it's our position that what has been done by David Owen, the lead investigator in this case, is a calculated, intentional burying of the most significant information that one can think of in investigating whether a case is a homicide or a suicide, especially when that suicide is the result of hanging. There's DNA in the hose loop, there's a piece of hair at the top of the hose loop, there's every single reason to believe that suicide by hanging was the method by which Sara died on May 20th, 2015. And whether Barbara Moore told David Owen on August 5th, 2015, as she remembers, or whether it was sometime later during their many phone calls, that doesn't change the fact that David Owen, the lead investigator, was in possession of exculpatory information, the most extraordinary type of exculpatory information that I could think of in this particular case, and he never said anything to anybody about it. So I believe there's a clear Brady violation, regardless of whether we're on the eve of a retrial or not. The issue really in Brady is, what's the prejudice to the defendant? And in this situation, what David Owen did was he kept that information from any pathologist that reviewed this case. It wasn't just Dr. Tormos at USC, but there were 7 other pathologists leading up to when he got an arrest warrant for Michael Colucci that reviewed this file, reviewed the evidence. There's an email where David Owen sent it over to Ann Williams, assistant solicitor here, and she forwarded it to MUSC for all of these pathologists to review the information. And David Owen never said anything about Sara explicitly saying she was going to hang herself to any of these medical professionals who have an obligation to look into and to be aware of the mental health of a decedent when they're conducting a medical legal investigation. He kept it from Dr. Tormos and the rest of the pathologists. He kept it from the judge who issued the arrest warrant in this case. He kept it from the judge that presided over the preliminary hearing in this case. And he kept it from the grand jury. And he kept it from the judge that presided over the last trial, as well as the jury that listened to the evidence in the last trial, which, as we've discussed, Judge, was an acquittal on murder and 10-2 in favor of acquittal on voluntary manslaughter. This intentional effort by the government, and under Brady, law enforcement is the government, to hide this information from everybody involved in the case is the kind of misconduct that we believe is extreme and warrants a response from the court that is much different than no harm, no foul. It's a retrial. You know it now prior to the second trial. That's just not enough. Especially when we've got a case that manner of death is undetermined. When we've got all this other information out there to support that David Owen's plan to bury this information was strategic and intentional. You've seen the clip, Judge, from the last trial, where the lead investigator, or the lead prosecutor, is conducting direct examination of Barbara Moore. And at one point, she proactively and explicitly says, don't say anything she said. despite not stopping Barbara Moore from giving hearsay testimony on why Sara doesn't go to the jewelry store anymore, because she told me that it was because of a fight she had with Michael. That was just prior to the statement that you saw in that video clip where Megan Burkstead, now Burleson, who just testified, stops Barbara Moore from talking about what Sara said on May 20th, on May, she believes, 6th, 2015, when she's in the garage crying, upset, as she testified. She stops her from saying that in a way that it's illogical to think that she wasn't aware of what she was going to say during that direct examination. You don't stop your witness on direct from making a hearsay statement. That's what the defense does. You stop it because you know it's going to hurt your case. That's the whole point in objecting to evidence or trying to stop evidence from coming in, is because you believe it's going to hurt your case. It is impossible to think that Megan Burkstead, prepped for trial, was told about that situation in the garage with Barbara and Sara, and that Barbara never mentioned to her that Sara said, "I'm going to hang myself if it weren't for the girls coming home." Crying, face swelling, drinking by herself. It really is unconscionable to think that Barbara did not tell Megan Burkstead about the specifics of that conversation. And we know she had to know something, despite getting on the stand and consistently saying, "I don't recall. I don't recall," over and over again. Perhaps that's code language to avoid a perjurous statement. She recalls what happened, but yet now they're in the bind of having to explain that they knew about it. And we believe that the reliability of the way that exchange happens on direct examination is clear proof that she was aware of it and that she did nothing to tell the defense about it because it would hurt their case. Judge, it's worth mentioning that this is not something that just involves a witness statement that may be able to be used as impeachment, or a witness statement that got shuffled, lost in the mix with numerous other witnesses. This is a statement from the mother of the deceased who testified at trial that she was told by her daughter she had a plan to hang herself, and she did it in the coming days. That's the statement that we're dealing with. And I believe it's imperative for the court to consider how significant that statement is, how it's really created this cancer that's gone throughout the entire case. Everybody's been affected by confirmation bias without that information. What the court has the ability to do today, Your Honor, is to exercise its power, its inherent supervisory power, and to dismiss the indictment, either with prejudice or without prejudice. We believe that the misconduct rises to the level of egregiousness that the court ought to send a clear message to law enforcement, to prosecutors, that this kind of misconduct will not be tolerated. And that you can do that today by dismissing this indictment so that it does not happen again. So that there is no close call where the prosecutor can get 2 bites at the apple because we didn't document it, we didn't take notes, sorry, we don't remember I was driving down the roadway. The idea that that is a sufficient answer for why you failed to turn over the most extraordinary exculpatory statement you could have in a case like this is totally unacceptable. If you dismiss the case with prejudice, obviously the case is over, and we believe nobody in this state, law enforcement or prosecutor otherwise, will ever hide such an important statement again. Or you can dismiss without prejudice. Case law in the state's very clear, Judge. The defendant's right to have their case presented to a grand jury is just as important, just as significant of a constitutional right as it is to have it presented to a trial of their peers. David Owen intentionally denied Michael Colucci of that right. And if you dismiss the indictment without prejudice, tell the government, present the case again. Make sure the grand jury is aware of this exculpatory information. It's the only fair thing to do. It's not as if we're dealing with a gunshot case where it's a stretch to say whether or not suicide was committed. We think one of those two remedies is appropriate, Judge. Anything less allows Michael Colucci to deny his constitutional right to a fair trial, regardless of whether he had a trial the first time. We don't think the government's disclosure now, although we certainly appreciate it, that doesn't cure the problem. There's a clear Brady violation. The only choice for the court is what's the remedy. And we believe both of those options are available to the court under its inherent supervisory power to send a message and make sure this kind of misconduct does not happen again.
Well, let me ask you this. You make a strong argument for a Brady violation. If he had been convicted at the first trial, the remedy would be you get a new trial. Here, he's at trial and this information is now available to you. How is it prejudicial to you to present a defense today? Now that you have that information, you can freely use it for impeachment purposes or whatever purpose you want to use it. It's now available to you. And that's usually what happens when you have a Brady violation, is you get a new trial and you can now make use of that information. So it's very, very, very rare that a court will dismiss a case from the state being able to bring it because of a Brady violation, and you have to show, well, it's so prejudicial to us that we wouldn't be able to present a defense.
Judge, I think...
You just want me to punish the state.
No, sir. I do want you to punish the state. I believe the conduct is egregious. But what I think Brady says is that there's a sliding scale by which the court can assess what is the appropriate remedy.
That's what I'm struggling with.
And I understand that. What we cannot get back, what he cannot get back, is the fact that none of the forensic pathologists were told this information. And they looked to the lead investigator to tell them what's the evidence in the case. They don't have the time to go out and get psychiatric records. It's on David Owen. We know that Dr. Tormos goes to the scene on April 12, 2016. She's got to measure the hose, Judge. That's how much they said, I'm going to turn a blind eye to this. I'm not going to provide the doctors with the information from the crime scene, let alone the information like this that says, by the way, this decedent told her mother, perhaps the most reliable circumstance you can find yourself in, when you tell your mother that you're going to hang yourself.
But these psychiatrists, or the pathologist panel, I guess, that they had, now would have that information available to them when they testify.
Yes, sir.
So again, I say, how are you prejudiced if they now have that information?
Well, it's because, Judge, we didn't know until just 6 days ago that the government was in possession of this information, that David Owen himself knew about the statement.
Yeah, but I understand the outrage factor of knowing that David Owen may have known. He denies that he knew back when, he denies that she told him in these meetings in, what was it, August, but of 2015. But you got knowledge of this at the latest in February of 2023, that Barbara had been told by Sara, I want to commit suicide, and I would if it weren't for my kids. So you've had that information for 2 years. So the fact that you didn't know that David Owen may have known it. I don't know how that changes the analysis from your being able to use the information that is relevant, and that is she told somebody, the state, at the latest, February 2023, this is a statement that Sara made to me. You've had that information for 2 years.
And Judge, I'll just tell you, that's just one of the reasons we believe that the Brady violation has violated Michael Colucci's constitutional rights. There are others, but to specifically address the forensic pathologist, we know confirmation bias exists. We know that. There's been studies about it. What he did was he facilitated that confirmation bias in those forensic pathologists. So we could never get the information directly from them at the time prior to a warrant being issued, prior to a grand jury presentment, that perhaps that would change someone's opinion. But it's just not that. It's also the fact that he presents the warrant to a judge for consideration for arresting Michael. He presents that information, or does not present that information, to a judge presiding over a preliminary hearing in which there's a close call of whether or not this ought to be bound over. And he didn't present it to the grand jury. Again, the case law in the state is very clear.
They had a preliminary hearing after he was indicted?
No, sir, prior to.
Okay.
Prior to indictment, there was a preliminary hearing on October 14th.
Who presented that? Was the state?
Megan Burkstead was the prosecutor.
Okay. At the preliminary hearing?
Yes, sir.
Okay.
And then we've got the grand jury, which the state has said, that the courts have said repeatedly, a criminal defendant's right to have an independent body assess the government's case is both equally a grand jury and equally a jury of their peers at trial. So what I hope the court can consider is that the overriding theme in Brady is to make sure prosecutors play fairly.
Mm-hmm.
Make sure the government plays fairly. They've not played fair. So then the issue becomes, well, how has he been prejudiced, as Your Honor mentioned? And I think the most significant way he's been prejudiced is by the grand jury. Again, we know it's an equal right. The grand jury was never given that information. We know that because David Owen has admitted he never told anybody until June 11th, 2025, in a case that's 10 years old, Judge. You heard the cross-examination from Ms. B, but for us filing the unusual motion requesting admonishment of David Owen, we may not be sitting here. We may not be having this conversation, but we might be having it in the middle of trial when I cross-examine David Owen. So should we lose our right to have his violation of constitutional rights remedied just because we're having the conversation now? I would hope the court would focus on the other part of the analysis, which is the deprivation of rights at the grand jury. That gives Your Honor an opportunity to say, you know what, I'm going to send a message, and that message is this indictment is faulty. Present your case to the grand jury, do the right thing, and present this extraordinary exculpatory information. And then if he's true-billed, we'll be back here and he can exercise his right to a trial in front of a jury of his peers. Because the case law is very clear in equally weighing those rights, I think that's why it's imperative, and that's why Your Honor has this opportunity, this unique opportunity to say, I'm not going to take away their right to prosecute. Absolutely. I think you should. So I hope I don't talk you out of that. But at a minimum, you can tell them, go back to the grand jury. This kind of conduct's not okay. I'm not going to let you shred notes and then come up here and talk about a memorandum or say I was told this driving down the highway and I didn't write it down. That's not what this is about. They have an obligation to document everything, especially something like this. So I think that's how we get around the fact that so many Brady cases out there after the first trial, when the information is disclosed prior to the second trial, the remedy should be, what the court should strongly consider, is that the remedy is, we're not, in this situation, when we know he never presented to the grand jury, we're not going to let his right to have the case presented to the grand jury violated, at a minimum. But I think it goes beyond that because of how egregious the conduct is. And for what you saw in the video yourself, Judge, there is no way that Megan Burkstead stops Barbara Owen during that direct testimony for hearsay. That's the defense's position to object to that. It was calculated. She knew what was going to be said. Otherwise, she would not have stopped it from being said. And so I think the evidence is very clear. Everything points to Ms. Burkstead knowing about it. David Owen has admitted that he buried it. And here we are, some 10 years later, trying a case again after Michael Colucci's rights have been repeatedly violated because of burying that important information. So I hope that you'll agree with me and dismiss the indictment one of two ways.
All right. From the state?
Yes, sir, Your Honor. As for Megan Burkstead stopping her during testimony, I think Ms. Abey presented testimony that she did that multiple times in Barbara's testimony. And I understand Mr. Bischoff's point that that's the defense's position, but actually the state has an ethical duty to not mistry the case if it's going to go against evidentiary rules, Your Honor. If she knows that something is going to be said that could possibly mistry the case, she has a duty to not allow the witness to say that. That's pretty common in trial, Your Honor, to make sure the trial goes off without a hitch and gets to the conclusion. And the only way to do that is if you know something could be said that could possibly mistry the case to prevent it from happening. There were multiple pretrial motions in the last trial to prevent as Megan said, to prevent the mention of the drugs and other hearsay statements. I don't know what Ms. Burkstead knew was coming out that was she needed to prevent, but it was in order to prevent a mistrial, Your Honor. As for the original statement that has been turned over, Your Honor, as you said, it was turned over in 2023. It is not a statement saying she is going to hang herself. It is a statement saying she is actually not going to hang herself. Now, this was turned over in 2023 as soon as the state actually found out. And under State v. Dennis, which is the new case on Stand Your Grounds, Your Honor, the common quotes from this trial are that a mistrial is the equivalent of no trial and leaves the cause pending in the circuit court. It says that these trials begin anew when called again for trial. It is the same as if no trial took place at all. Rulings made within reference to the admissibility and competency of the testimony result in no binding adjudication to the rights of the parties. And they go on to cite a rule from the neighboring state of Georgia that the grant of a new trial restarts the entire prosecutorial process, including an immunity hearing. Now, obviously, in this case, we don't have an immunity hearing, but I believe the underlying idea is the same, that once that mistrial happens, Your Honor, that trial is a nullity. That trial is done. We start anew, and in terms of that, there is no Brady violation in this case. Everything has been turned over to the defense. They have admitted they have had it since 2023. And even if we do go back to the prior discovery before the previous trial, the fact that she had made suicidal statements was turned over. David Owen wasn't hiding those from the cell phone extraction. That entire cell phone extraction was turned over. And in that cell phone extraction were those statements. David Owen went and got the psychiatric records and turned those over. Your Honor, he keeps bringing up the fact that the pathologist needed this stuff to rely on, ignoring the fact that the majority of the pathologist's work is the autopsy in diagnosing those internal injuries. He's free to ask her if, knowing that she had made this statement prior to her report being filed, that would have changed her opinion. He's happy to ask that and accept the answer that she gives. Your Honor, but as in terms of just the Brady motion, in this case, there is no Brady violation. The evidence was turned over in 2023. As soon as the state came in possession of it, Your Honor, I think it shows that we turned it over basically the next day because we knew it needed to be turned over, so we turned it over. As you said, Your Honor, as you were talking about, the most appeals courts and et cetera, when they give the remedy for a Brady violation, the ultimate remedy is, as you said, to retry the case. The quote from most of these cases is that it would need to be an extraordinary result to give a dismissal, Your Honor. And that's where we are at today, Your Honor. They have not been prejudiced. They have the information. They've had it for 2 years in order to prepare their defense. And I don't think the violation, the retroactive Brady violation for a trial that ended in a mistrial is worthy of an extraordinary result, Your Honor, when they've been able to prepare their defense for the last 2 years with this information. And in that regard, we don't think there's even a Brady violation in this case, Your Honor. Thank you.
All right. Do you want to respond?
Just very briefly, Judge, it's our position that the Brady violation didn't occur until June 11th, 2025. And that's when we knew that the government official, the main investigator in the case, was aware from Barbara Moore that Sara told her that she was going to hang herself just days before she died. All the other text messages, yeah, we're aware of those, but nothing that says, I am going to hang myself. Much different than any other statement of suicide, because she ended up hung in a hose. I mean, so I don't think the comparison is really a reasonable one in light of the government's obligation through their lead investigator to turn over exculpatory information. And I'll just tell you, the idea that there's no obligation for someone who's conducting a death investigation to turn over mental health history to the forensic pathologist is just ridiculous. That is his obligation as the lead detective. And he didn't do it, and he buried the other information because he knew that it would hurt their case. Again, we've given you an opportunity, Judge, or an option to consider not just full dismissal, but dismissal without prejudice. Either of those two remedies would cure the misconduct. Again, we think it's so egregious that the dismissal outright sends a very clear message, but at a minimum, we hope you consider dismissal without prejudice.
Mr. Kozak, let me ask you a question that occurred to me, but I forgot to ask it during your argument a minute ago, and that was, y'all wrote this, you had, what was it, Langford, I believe, write this, or Ellis, excuse me. Ellis write this note in February of 2023 that it says the AG's office met with Barbara Moore on 2/16 representing an upcoming trial, and that she stated at that time Barbara met with, she went over to Michael and Sarah's home, found her in the garage. Sara was upset and told her that if it wasn't for the kid, she'd hang herself. And so you had Ellis write that down in a memo, send it to you. Why then did you feel it was necessary to 2 weeks ago, or on the 16th, disclose that again as if it were new information? I don't understand. Was that because that was the first time you found out that Owen knew about it ahead of time?
Your Honor, the pretrial motions, we thought after the pretrial motions, out of an abundance of caution, we should follow up with those witnesses about those questions. And then once we got the answers to those questions, we then, obviously as our ethical duty, turned those over immediately to the defense. That was directly a result of the pretrial motions and what was discussed at the pretrial motions.
So it's your position that in 2023, you knew about the conversation with Barbara and you turned it over to the defense. But in 2025, recently, that's the first time you found out that David Owen
Yes, sir.
might have known about it
Yes,
as
sir.
well. Okay. All right, I wanted to clarify that. Okay. I need a few moments to think about this, so let's take a recess for a few minutes and let me give this some thought. Okay?
Thank you, Judge.
Be seated. All right, you ready, Madam Court Reporter?
Yes, sir.
All right. All right, well, I've considered this matter, and I want to make clear that when I speak of prosecutorial misconduct, I want to make certain that you understand that I'm not speaking of members of the prosecuting attorneys per se, but because of state actors for whom the state is responsible. Under the case of Kyles versus Whitley, this case alleges that the husband of the deceased murdered her, and the defense claims that the deceased committed suicide in part because she was still emotionally distraught by the suicide of a previous husband. And the date of this incident was right around the anniversary date of that suicide. This was a very unusual and dramatic suicide, and it was known to family members that the deceased never got over it and had a very difficult time emotionally around the anniversary of that suicide. The critical issue in this case was that the deceased mother went to the deceased home several days before this incident and found the deceased in a very emotional state, and she told her mother that she wanted to kill herself by hanging. But she did not want to do that to her children, and the mother was so upset that she wanted to have her hospitalized. And after the deceased died in this case, the mother has now testified that she told the lead investigator about that incident within a few days. The lead investigator denies that she told him at that time, and he buttresses his story by pointing out the mother hand wrote out her statement, and she did not mention this prior statement or this prior incident in the written statement. Well, the defendant was indicted at the first trial, ending in a mistrial. The mother did not mention the prior incident at that trial because she was cut off by the prosecutor when she started to talk about what the deceased said. The prosecutor testified that she cut her off because of hearsay concerns. I note there was never any attempt by anyone to allow the mother to testify about the deceased statement under 8033 under our rules of evidence, so the court never ruled on it. But while it was known to all that the deceased suffered from severe drug and alcohol abuse and was being treated by a psychiatrist at the time of her death, evidence was presented at trial of the same. It's very troubling that the evidence that the deceased made specific threats of wanting to kill herself just days before she died. This information was kept from the jury. By state action or inaction, had the defendant been convicted, this court has no doubt it would have been considered a Brady violation, and the defendant would have been granted a new trial. The beginning of a new trial is exactly where we find ourselves today. The state argues with some authority and precedent that basically this court should treat it as the equivalent of no harm, no foul, and that now that this information is known, it can be presented to the jury, who can evaluate it and give it whatever weight it determines it deserves in arriving at a verdict. Indeed, this court believes that it is a choice among several that would no doubt be upheld on appeal if this trial were to go forward and the defendant was convicted. However, this court believes that our courts should demand better from the state, and to simply allow this trial to go forward with so many witnesses, such as pathologists, having been denied the opportunity to have this critical knowledge available to them when that material was fresh, amounts to a foul with a harm. Therefore, this court is quashing this indictment without prejudice and ordering that if the state wants to retry the defendant, It is to do so only after the case has been resubmitted to a grand jury who shall have the benefit of the full measure of evidence this matter deserves. This court recognizes this is an unusual remedy. However, this is an unusual case. And this court urges the Attorney General to present a fuller case to the grand jury than is usually done in state court in South Carolina. The goal is to do justice, and this case deserves a fresh restart in order that the citizens of South Carolina can have full confidence in whatever the jury's verdict may be. It is so ordered. All right?
Thank you, Judge. We are grabbing an exhibit to supplement into the court record of a text message that was shared on May the 12th, which would have been, I believe, the same day that they're alleging this happened, where the victim says, I'm sent to Michael, I'm telling you that I love you, I'm shooting myself in the woods. That is a specific example of her saying that she's going to kill herself, which was one of the reasons why you stated that, Judge. So we just want to supplement that into the record since that was turned over in 2016 to them as well. So we will be adding that as a court's exhibit.
Judge, likewise, we have the videos that were played during the hearing on a thumb drive labeled as court's exhibit number 4, and we believe also needs to be part of the record.
All right. Now, I have quashed this indictment. Therefore, there are no charges pending against Mr. Colucci at this time. So there's no longer a bond on him, and he does not have to have electronic monitoring. If and when he is re-indicted, then bond can be addressed at that time. All right, we're adjourned.
Thank you, Your Honor.
I'm going to go address the jury.
Yeah, happy to.
Great. How does it feel right now?
Very blessed, very grateful for the judge's decision. I'm very grateful for the team that I have for all these years.
How surprised are you?
I'm surprised the truth is known. I'm very just blessed. That's all I got to say. I'm at a loss for words right now.
Has the state signaled anything regarding their intent to re-indict or not?
No, not at all. I mean, look, the bottom line is we're very, very appreciative of Judge Young doing what we believe is the right thing. We have worked tirelessly on this case after Andy, my longtime mentor, has done so much work in this case. The level of commitment from Andy and his office just basically laid the foundation for Bill and I to come back and work with him again. It's been an honor. We are just really proud to be part of such a good team of lawyers who are committed to our clients, and we're just very, very happy for the decision today.
How rare is this in South Carolina courts to see a murder indictment quashed day of openings?
I don't know. I mean, look, we've been talking about it for a while. In terms of the opportunity, we believed in our argument. We spent a lot of time making sure that the law was on our side, and I'm not familiar with a situation where this has happened. Maybe it exists, but all I can tell you is that we believe Judge Young did the right thing.
Did you have any indication, that Judge Young might be open to it given his ruling in the Justin Turner case where he dismissed that case with prejudice?
No, it didn't really cross our mind. I'm familiar with that case.
Yeah.
I think Judge Young does what he believes is right when the information's presented to him, and I think that's kind of what happened today.
Mr. Savage, your thoughts on this? I mean, this must have been quite a moment after all of these years of
Well, number one, I'm glad to be associated with Michael. He's just been the best ever client. horrific. You know what people don't realize is the damage that's done. Not in the courtroom, but having to live with his daughter, whose mother died. You know, the emotional damage that's been done to him is incredibly rich. So I'm hugely happy for him, and I'm hugely happy that our criminal justice system has a judge like Judge Young. You've been with us through the last 10 years. You'll see that some judges pay closer attention to the facts and the law and the arguments of counsel than others do. I can't recall a finer judge than Judge Young in terms of listening, not his rulings, but just giving the lawyers and counsel an opportunity to be heard. And I'm very, very happy with that. Naturally, I'm overwhelmed by what Scott and Bill have been able to do. When they say that they have worked hard on this case, I'm talking about this young man just left his family in Ireland on a vacation that had been planned for years and came back to be here with Michael. Scott has been in my office 24 hours a day. He's got his own key. So, I mean, he just worked and worked and worked and worked. And credit to your wife.
Yes.
Your wife will have the understanding of allowing my husband the time to bring justice for Michael. It's a remarkable day. Somebody asked, has this ever been done before? I've been doing this for 50 years. 50. That's all.
That is.
Never heard of it. It's never crossed my path either individually or just knowing the law and practice in South Carolina. I've never seen on the basis of prosecutorial misconduct. And if you think about it, you don't have to be a lawyer. This is a troubled woman who Michael took care of, who unfortunately died for many reasons, none of which were brought about by Michael or anything that he did. So this is not a happy day. I don't think so. I don't think he would say, how do you feel? I feel happy. I feel satisfied. I feel like finally somebody has listened and justice has been done. And if I'm happy, I'm happy for you, Michael. Michael, think about this. Hold up your leg. Don't understand.
What do they not understand,
He
Mr. Colucci?
spent more than $27,000. Think about this, $27,000 he spent.
The things that normal people get to do, to go out in public, to spend time with families, go out in the water, to do just basic things. Outside of sleep in bed, you gotta have a cord attached to your leg. The neuropathy that comes from it, if you read, they tell you that this is a byproduct of having it for 6-7 years. There's so many variables that go along with it, I'm just very grateful that my daughter and I, and the rest of whatever family I have left, and I'll do the best I can. That's all we can do. And I'm very grateful for all of your coverage. I'm grateful for your patience as well. Thank you.
One other thing. Look at the men behind us. The Sheriff's Department turned this case down 10 years ago. The solicitor whose office is right in here reviewed the case, met with the pathologists, met with the investigators, and turned the case down. This case should never, ever, ever have been brought to the court. And thank God for your talent. That ended it, hopefully ended it today.
I think a lot of people, especially perhaps Mr. McGuire, were struck by the combative demeanor shown by the prosecutor from the first trial on the stand today. What did you make of that? And have you ever seen that type of combativeness from an officer of the court in that context?
No.
Simple answer. Anybody got anything else?
You go through your thought process when you learn the information that is the subject of the Brady hearing today.
What's my thought process? So this is obvious. I mean, somebody who, the pathologists and all the investigators in the corner of this county who ought to be praised too, because remember, he did not believe that this was a homicide. The elected official in Berkeley County did not believe that this was a homicide. So when the information that I'm going to commit suicide is withheld from everybody, not just Scott and Bill and myself, but from the 7 pathologists who reviewed this case. My thoughts are the criminal justice system suffered by the actions of the prosecutor, who was the lead prosecutor last time around. Somebody asked about her demeanor. You must have not been here for the first trial.
I was not, sir. I was not.
we had a preview of. I got to be careful.
Fair enough. Fair enough.
Just leave it at that.
I guess just the mechanics, for people to understand, how did this information come to light in the last week or so about the retired special agent's knowledge of this statement for so long?
Well, I mean, the Attorney General's office, after we filed the motion to admonish the lead investigator for not correcting other false testimony, this is not the only testimony, there was other false testimony, they began to ask specific questions that we believe probably should have been asked a decade ago. And then we got the memorandums on June 10th and June 11th confirming what we had suspected all along, and that there were clear Brady violations. And so it was given over to us, and when it was, we put together the argument that you heard today, where it's not just about having it on the eve of a retrial. It's about all the other days, however many that is, 365 times 10 years, that it was withheld from all the folks who are involved in the case. And that confirmation bias, not having that information is so powerful, and I'm just glad that Judge Young recognized that like we did, and decided to dismiss the indictment, which was the right thing to do.
Anybody got anything else?
Mr. Colucci, what does it feel like to have your daughter with you on this day?
I'm glad you said that, because as people focus on how it's affected me, I don't think the world understands. My daughter's only 20 years old, so for 10 years, half of her life, she's had to deal with this, amongst other things, and you can't take back that time. If it wasn't for the support of the community that we have, I don't know how we would have done. And I'm very grateful for the attorneys. They're not just attorneys. Once they knew and they understood, they believed, they knew that this was wrong. And I can't tell you on Sundays, how many Sundays I'm contacting. These guys are back and forth nonstop. I can't tell you the endless support by select families that have gathered around us. I'm just very blessed by God and very fortunate that my daughter's here, and the other special people that are close to us are here to support us as well. And thank you all. So, thank you.
What's the first thing you're gonna do?
Get this thing taken off.
Well, we appreciate y'all's time. Thank you.
Yeah,
for your
thank you.
time, sir.
Good to see you.
Sure.
Thank
You said there was false testimony. What is the true testimony from Barbara then?
I don't know.
Was there a statement made to her about about her she intended to commit suicide?
Well, so the false testimony that I'm talking about,
Yeah.
that was the subject of the motion to admonish David Owen,
Oh,
was
yeah,
when
that-
she said for the first time in trial in 2018 that Sarah was going to leave Michael on Saturday before she died, and that she told her that during a phone conversation. She never mentioned that to anybody, not in her first statement, not in her second statement, not in her third statement. That was the fourth statement she gave about what she remembers from that phone call. And the whole time we've listened to it, we've thought, if that really happened, you would be going to the scene that night. You would be telling everybody, wait, what are you talking about? My daughter died? Well, you need to investigate the guy who she said she was leaving in a couple of days. But that never came to light. And so that's the main problem with that line of testimony is that it just seemed like it was being developed for purposes of trying to hurt Michael, of trying to hurt the defense, and we don't believe it was truthful at all.
And then, so what about the veracity then of the statement about her wanting to commit suicide, and her coming over to the house? When did that come to light?
No problem.
Initial feelings walking out of courtroom right now?
Surprised, you know. I care about Michael in this work so much. You just don't see that happen. You know, I think people don't understand that this is a pretty large-scale form of misconduct, but we deal with hiding information. We deal with not turning stuff over. You know, it's not often, but it happens. And for a judge to really listen to us about the severity of this particular, bearing of evidence, the Brady violation, and to take into account how many days it deprived Michael of his right to a fair proceeding, to due process, and to listen, to really listen, you can't ask for anything else.
You talk about that time lost. Is there anything you want to say about the amount of time you've been on the case, the time before that, maybe what this remedies, or if it could remedy all that time?
You know, look, I love the work. Bill loves the work. There was really no greater joy to me to work with Andy again. He's been such an incredible mentor to me for so long. To come back and work with him as closely as I have, and he's not in the best health, and for us to be able, and Bill too, who also worked for Andy, to step in and help him out when he needed it, means the world to us, and we believe in Michael. And so you put those two things together, and it's just, there's a lot of professional satisfaction that comes out of the hard work that we put in, and certainly the result.
What do you think this says about the way that our investigations, either locally or maybe our justice system, overall works? You mentioned it seems like there can be a lot of issues, but maybe this is a time where it worked out correctly?
Yeah, I think this is a fringe problem. What happened here over the past 10 years is a fringe problem. So I think that ultimately we're just very happy that the judge did the right thing and dismissed this indictment. We are hopeful that the Attorney General will let this be the end of it. As I've said to many people many times who've asked questions about this case, there is an overwhelming amount of evidence that Sara committed suicide that day. There's no doubt about it in my mind at all. And to contemplate recharging Michael or trying to charge him again, I hope that that's not what happens. It's not what should happen. But if it does, we're going to be here to support him again, and we'll be here to defend against another baseless allegation.
The state's response was that they had this information and turned it over to you in 2023. How was this new information different than what you learned in 2023, enough to make it enough of a Brady violation?
So what they turned over in 2023, despite their argument to Judge Young, that was not the moment of a Brady violation. That certainly was not the moment of potential prosecutorial misconduct. That was a moment in which they gave us information that we didn't have before, and then, but for our filing of the motion for admonishment on false testimony that had nothing to do with this Brady issue. I don't know if they would have asked the questions that apparently they did ask last week leading up to trial. And so as I argued to Judge Young, the Brady violation was in the moment that David Owen confirmed that he had that information close in time to when he began investigating the case and never told anybody about it. And as I told Judge Young in my argument, and I think is reflected in his order, that misconduct, hiding that information, affected every single person that looked at this case. It affected Michael's right to have a judge determine whether or not there's enough to issue an arrest warrant. It affected the judge's decision at the preliminary hearing. It affected his right to have a competent grand jury hear information. So the culmination of that can't just be, no harm, no foul, wiped away as they were asking the judge to do, because they turned it over at the 11th hour in a decade-long case. It does not get any worse than that, and we're just glad that Judge Young issued the order to dismiss this indictment.
How does this case compare to all your previous work?
I've never spent any more hours on a case than this one. And I can't thank Bill McGuire enough, and Andy enough. It's really hard to talk about how many hours go into this, and just really happy for the team, for Michael. I've never had a case like this.
Do you feel confident about your position if the state pursues charging him again? And do you expect, it's hard for you to say, but do you expect that to happen?
Look, I don't know what they're going to do, but if they want the fight, they bring the fight to our doorstep, we'll be ready.
So appreciate your time.
Yeah, you're welcome.